Hi guys, welcome to my channel. My name is Diana Romanowska. I am a certified family law specialist, divorce attorney, practicing family law, prenuptial agreements in the Bay Area, California. Today I would like to talk about jurisdiction. I have an example, a case where a spouse took child from another state, let's say Texas, from Texas to California, and filed for divorce and domestic violence. And domestic violence happened in Texas. So think about this. If something happened in Texas, why wouldn't she file in Texas? Well, because if she talks to two different lawyers in Texas and in California, she would be advised that once she is 6 months in California, the child will have home state and she can establish jurisdiction. The other parent, father, mother, is far away, so they would have less visitation. How will the court look at these type of cases? If father files, or the other parent who is fighting this, files for response, whether it's response to divorce she filed, whether it's response to domestic violence, and does not object to jurisdiction by saying, I'm special appearing, I'm not assuming jurisdiction, then the court will have jurisdiction over me if they don't do that. So, but there are two types of jurisdiction. One, personal jurisdiction, and one, subject matter jurisdiction, meaning over the issue. So, court only has personal jurisdiction if the other parent from Texas has either has been served in California, or this person has minimum contact, business in California. Any documents, for example, driver's license, basically has contact to California. Just owning real estate is not enough. When I'm talking about connection, real connection. So, how can that person lose connection or waive objection to personal jurisdiction, meaning the court will have personal jurisdiction if the other parent files for legal separation because they're not 6 months in California, and they file domestic violence and they serve the parent who is in Texas, either in California or in Texas, and serve them in person, and they respond without objecting to jurisdiction. That's how court will have personal jurisdiction. I hope I make sense. Basically, even if the court has personal jurisdiction, even if that other parent didn't respond but also didn't object within 30 days, they waived. By not objecting within 30 days to whatever they filed, they waive. So the Texas parent is going to have personal. So it's kind of hard to escape personal jurisdiction. You hear me on that, right? But if everything happened in Texas, that means the court does not have, California court, subject matter jurisdiction. Because witnesses over the incident are in Texas, pediatrician of a child, family members, friends, work. The courts don't want really, let's say in California, to deal with parents who are trying to establish new jurisdiction when everything happened there. All right, so I'm not going to bore you with case law and code sections. If you're interested, just ask me in the comment section below. But even though the court has personal jurisdiction, the court might say, I don't think I am the convenient forum for this case. So therefore, the court will move the case back to Texas, back to another state to resolve let's say domestic violence or divorce, because here we have legal separation in another state. So you might have heard the term jurisdiction shopping. So when you are the one on the defensive side, meaning if someone shopped for jurisdiction, make sure if you are the one who is in Texas to file things right away, such as if they filed for legal separation, object within 30 days. File for divorce in wherever you are. If they ask for domestic violence, ask for custody orders returning the child right away. Just create a case number in your original state, because if you don't do anything, after 6 months, the other parent who was trying to escape and have a child, have home state, will have jurisdiction in California. Now, if you're on California's side, then it's a tough one, because even if you serve the other parent in California, the court still might deny jurisdiction over the issue. So it's a tough position. Then if I were you, I would negotiate with the other parent to say, okay, I want to live in California. Let's create a schedule that I like. And by filing a domestic violence based on incident that happened in another state is not going to do it. So both cases that I'm talking about, one is to be decided about subject matter jurisdiction, and another case is is an appeal. So we'll see how it's going to go. But as of right now, typically, based on the code section, based on the law, the court... Oh, and then let's see this. If the court does not have subject matter jurisdiction, does not have personal jurisdiction, but you are the one who is in California for 6 months and want to get divorced, you can get your marital status terminated. It's called bifurcation of a marital status, which I have another video completely about that topic. So this is how jurisdiction forum, convenient forum is gonna play together when it comes up. I hope that was helpful, and I will see you soon in my next consultation. Bye!